Warning, censorship. Warning, censorship.
The fixation on sanitization and hypochondriac ideation has led society into a weird place legally, with continually shifting goalposts from government officials and a revolving door of legislation that changes endlessly. We haven't seen anyone utilize a balanced approach in a year and a half. For Rebel News, I'm Tamara Ugolini, featuring one of the talented lawyers who we have hired through our civil liberties campaign at fightthefines.com. Amanda Armstrong is a lawyer at Nirmala Armstrong Law. That's a boutique firm in Markham that has decided to focus specifically on COVID-19 cases and health orders in wake of unprecedented hits on the democratic and due process. See, I originally wanted to catch up with our I Will Open case turned Fight the Fines case, Alexandra Stewart of Stewart's Decorating. But after she was smeared by her local media when her medical officer of health in North Bay issued her a restraining order for the criminal act of wanting to earn an honest and independent living. After speaking with her lawyers, of whom is Amanda, we decided it would be beneficial to have a more broad discussion surrounding these public health orders and the reopening of Ontario Act legislation. Here's what Amanda had to say.
There's this legislation called the Reopening of Ontario Act. And under that, there's regulations. So we know that there's regulations for stage 1, for stage 2, and for stage 3. So that all in and of itself is already a confusing aspect. Now, what we've seen is, to say the least, very confusing frameworks. This was represented from a staged approach, like in the regulations. We've come up with terms like non-essential and essential, curbside, stuff like that. Then we've even seen color coding systems. Then there was an emergency break on the color coding systems in that framework. And now we're even as recently, we're back to some forms of steps. So those are confusing and it's hard to navigate. And because it's so fluid, it makes it really difficult for businesses and people to navigate these issues. And when does what apply and how? So what we're seeing is, in the legal context, is a compounding and an escalation of punishments. Now, in the legal sphere, these are being done without any actual due process. Now, what that means is that a business or an individual is being issued with the lowest. We'll start with provincial offenses. So offenses under the POA. Now that court system, the provincial court, is already bogged up. We know that the court systems have their own timelines, their own time frames, and that requires time. But on top of that, those provincial offenses, and without having heard the merits of the case on those offenses, those initial offenses, those POA offenses and notices are now being the basis and reasons for issuing a Section 22 order under the Health Protection and Promotion Act, also referred to as the HPPA. Mm-hmm. So that becomes problematic in and of itself. We see the compounding and the escalation. And it goes even further, because what we have is we have clients met with POA offenses, Section 22 orders under the Health Protection Act, and then there's even Section 102 orders. These are restraining orders under the Health Protection and Promotion Act. And what are they prefaced on? Well, they're prefaced on, as a foundation, the Section 22 order. And we know that Section 22 order is prefaced on the POA offenses. So here we are. It's very problematic. Steps are taken up the ladder when the business or the individual has not had their initial issues adjudicated on, aka those POA offenses. Mm-hmm. So this is a real concern that we're seeing with due process today in the legal sphere.
And that's what we're finding with some of our businesses and people who are being represented under our democracy fund here. Going back to that classification of definitions of what's essential, non-essential, what does the role of even business classification play in how you're fighting against this legislation? So do these definitions of curbside pickup and essential, non-essential, do they muddy the waters or do they make it more clear?
Yeah, see, that's another great question. And that's another issue that we're seeing. These classifications really are proving to be a point of contention in litigation. As we see it right now, the interpretation is really all over the place. It's left with citizens, it's left with bylaw officers or other enforcement, it's left with politicians, and it's even left with us as legal representatives. So with these different interpretations and this many different interpretations, it's really not acceptable to have this uncertainty and this lack of clarity when we're trying to enforce rules and regulations, because what it ultimately does is it causes a disastrous opportunity for ambiguity and uncertainty. And this is important because civil liberties are at stake, rights are being limited, infringed. So it really becomes a problem, and this nuance and these theories. So even presently, when we go to these terms and these classifications, I can't even tell you personally what is meant by essential or non-essential. What we know is that these are political terms, and quite frankly, they are problematic in and of itself. Because I would even suggest that if you're saying that somebody's business or their line of work is non-essential, well, this will have further impacts on both their mental thought process, their mental psyche, and this can lead to negative repercussions, especially during an already stressful time that we've been in for the past year and a half. So what this does is it's going to be noted in the collateral damage, and we're going to see impacts of all of these nuances and these lack of clarity and these uncertain terms.
Absolutely.
And now, even what we see is that we see a definition section usually in legislation. So when I looked at the ROA, the Reopening of Ontario Act, I saw that it has a definition section, but there's only 4 definitions. So those do not provide clarity to the terms of essential or non-essential or even curbside. So what does curbside mean? Well, me as a business or even as a customer, I am uncertain, because does it mean that I get my product brought to my car? How do I get the product in the first instance? Do I have to order it online? And if it's brought to my car, is it going straight into my trunk, or do I put my hand out the driver window and get it from there from an employee? Do I have to call ahead? Do I have to go to the curb or to the front door and knock, and then somebody leaves it outside the door and then I return and pick it up? So this uncertainty and this ambiguity, it's really not helping, especially when it's coupled. And we really have to look at this, and this is what we do, as we take every client as they are in their unique circumstances. Because when you look at the uncertainty and the ambiguity of these terms, and then you couple that with the uniqueness of every business, and then you take into consideration their ability to even fulfill these requirements or these expectations of curbside and limitations. And then you even add in further their interpretation of these requirements. And it really is a muddied water. And it's really important that some of this is at least delved into, and we seek some answers on and clarity on some of these issues. And then the last thing that I want to talk about is just that what's really problematic too is that some of these businesses don't even fit neatly into these arbitrary classifications of what business is. Like, some of them are retail, but some of them are also suppliers. So what do you do when there's a contention in the legislation or the regulations? When you're forced to close, but as a supplier, you're allowed to open? Do you only operate in the capacity as a supplier? What about as a retailer? So that's problematic. And then I won't even get into it, but there's also issues as consumers. What happens if I can't order something online? I don't have a smartphone. I don't have a visa. I don't have a home address, stuff like that, or I don't even have a car. So that becomes another issue. And what we're seeing is a real lack of structure and actual clarity.
Those are some great points that you make that a lot of people, I don't even think, realize, who might not have, like you say, a credit card. And so to get justice for these people, first of all, we know that the wheels of justice are slow turning. What are some additional frustrations that you've seen in trying to push back against this ambiguously worded legislation legally?
So that is a great point. That we do know, as I stated, that the wheels of justice are slow turning, and that is a real concern as legal counsel, especially when there's so much fluidity going on right now, and has been going on for the last year and a half with these rules, these regulations, these stages, etc. So with the slow wheels of justice turning and the ever fast shifts from open to slightly open to fully locked down, and then back to some form of restriction and limitation on opening. With those changes, there are instances where these challenges and our clients' positions and their orders and their fines become what we call moot. So what I mean for that is, and I'll provide an example of mootness. So if I, as an enforcement officer, and you as a business owner, for this example, if I go to your business and say, I'm going to issue a closure order against you, and the basis for that closure order is stating that pursuant to this regulation of Close Your Business Act, Section 1, it says that your business has to be closed. So I make a closure order against your business, and it is valid because it says, hey, all I'm doing is just reinforcing this regulation and this legislation that says your business has to be closed. Well, what happens if there's a legislative change? And that's what we've seen, especially with this restructuring and these different approaches to opening and restrictions. So if Section 1 of that legislation now changes and says your business is allowed to open, or if Section 1 is completely gone and your business is allowed to open, then what happens to that closure order? Well, that closure order becomes moot because I can no longer force you to close off of what I said was Section 1 because Section 1 doesn't exist, or Section 1 is saying now that you can open. So that's mootness, and that is really problematic when it comes to the timeliness of bringing these challenges. It becomes really redundant and funny because it becomes a challenge to even bring these challenges. So what we're left with as legal counsel is a balancing approach of trying to get the client's matter adjudicated on before an issue of mootness even presents itself. But we're also trying to put the client's best foot forward, and that takes time. It is expensive, and the results are still uncertain. So these issues are very timely, and there is a need for answers, but just getting those answers has been proven to be difficult in and of itself.
Mm-hmm. Truly sounds like unprecedented times in all avenues of this pandemic. Now, off camera, we spoke that your legal team has sought clarification and has posed questions to health units, medical officers of health. Can you share some of their responses?
Yeah, so that is correct. Our office, Amanda Armstrong Law Office, has been dedicated to COVID-19 related offenses. It's all about access to justice, and we recognize that the access to justice wasn't being encouraged or even available to those who are faced with COVID-19 related offenses. And that is a real problem when it comes down to the narrative and the merits of the case. To go to court, you can't just present one side, and you can't just always claim pandemic. There is a flip side to all of this, and another side that has to be heard so that a full picture can be painted for a judge or an adjudicator. So what we've seen in our office is that there's been an expeditious approach from health units to enforce and bring actions against businesses and individuals, which is okay, sure, if you're going to claim public health and communicable disease or health hazard, then sure, you may be able to do that lawfully under your Health Protection and Promotion Act or health regulations. But at the end of the day, we still have to look at reasonable grounds for doing that and the allegations being made against our client. So what we've encountered in trying to seek clarification and get the matter adjudicated is that there's instances of delay and ambiguity leading to even more legal fees incurred by our client. So this has been a real problem because at the end of the day, it is unfair as a health unit for them to work quickly to issue these orders and these fines, but then they take their time in responding to requests for clarification, for disclosure, or even to work towards a resolution where sometimes that could be an actual viable option. But we're faced with so much delay and so much hesitancy and no cooperation that sometimes it really goes back to that matter of mootness where the timeliness just doesn't work in our favor or in our client's favor. So an aspect of dragging their feet. So unfortunately, the best that we can do as legal representative is and as citizens is to ask these questions and to raise these concerns so that maybe we can argue for our client and try to submit the best position and game plan. Because at the end of the day, if we don't ask these questions and raise these concerns, we will never get an answer or any clarity on any of these issues. And right now, we are at a point in time where it's over a year into this situation, and we still have more concerns and unanswered questions, which is completely unacceptable. As citizens, we have the ability and we have the right to basically seek clarity by asking the following, like, what is going on? Why is this happening? And how do we stop this? And that's where we at this moment in time, is asking these questions and pushing and lighting a fire to get these answers.
Thank you very much, Amanda. I really appreciate your sentiments. Did we miss anything in our chat here that you'd like to, any last thoughts for our viewers?
Well, I'm just hoping that this will shed some limelight as to the legal approach and what's happening on the other side. When these orders get issued, what is that process? What happens? And why haven't we heard of more challenges? Well, at the end of the day, it is a challenge to get these challenges even heard and adjudicated. So at the end of the day, what we're left with is still trying to fight and trying to find the best avenue and work expeditiously while also putting the best foot forward for our client and working in their best interest. So I'm thankful to Rebel News for even shedding a light on these issues and getting the matter out there so that the ordinary citizen can realize that this is a nuanced and ambiguous field that we're playing in, and it seems to be unfair, and there are avenues to take, but those avenues sometimes close off. So we're hoping for the best, we're working for the best, and at the end of the day, any answered questions will be beneficial in moving forward, and we're hoping for that.
Now, I'm no lawyer, but ambiguously worded legislation that is open to the interpretation of the person enforcing it screams unconstitutional. We have these checks and balances in place for a reason, and I'm glad that we are spearheading this accountability campaign and hiring lawyers like Amanda and her co-counsel at Tamara Armstrong Law to restore those checks and balances. For Rebel News, I'm Tamara Ugolini. Like Amanda said, working quickly and then having to change directions when the regulations inevitably change is costly and cumbersome. We've put these fines under the broader umbrella of the Democracy Fund, which means that your donation to our Fight the Fines campaign is a charitable donation. If you want to help us continue our civil liberties work, please consider donating what you can at fightthefines.com and get a receipt to claim it. That's fightthefines.com.